South Africa's Constitutional Court case on dual citizenship echoes a changing society. In a pivotal moment for South African citizenship law, the Constitutional Court entertained arguments on the topic of dual citizenship, a legal inquiry poised to have profound implications on the concept of national identity in the Rainbow Nation. Under the current South African law, citizens must seek permission to retain their South African citizenship when voluntarily acquiring another nationality. This regulation has resulted in inconsistent decisions from the Minister of Home Affairs, with no defined criteria for granting such permissions, often leading to a perceived luck of the draw for applicants. A challenge to this status quo was spearheaded by the Democratic Alliance, DA, which sought to confirm a Supreme Court of Appeal, SCA, ruling that the government's power to revoke citizenship based on dual nationality is impermissible. Dr. Aaron Motsoaledi, former Home Affairs Minister, initially opposed the case but later declared a non-contending stance before the election this year. His successor, Leon Schreiber from the DA, similarly did not argue against the SCA's decision in court, stating the ministry would abide by the Constitutional Court's resolution. The SCA had condemned the arbitrary nature of the Homeland Ministry's decision-making, prompting expectations that the Constitutional Court will align with the global trend of accommodating dual citizenship. Statistics suggest that acceptance of dual citizenship is growing worldwide, with around 76% of countries acknowledging expatriate dual nationality. This shift is noticeable within the South African context, where travel and international opportunities have rendered multiple citizenships more prevalent, particularly among the elite. Politicians and leaders, many with family members holding dual citizenship, are showing increased understanding of the nuances involved, a considerable evolution from an era when dual citizenship might have been a contested issue between opposing political parties. Former PRASA CEO Zolani Matthews and Deputy NPA head Anton du Plessis have been notably affected by this issue, having security clearances denied over their dual citizenship status, instances that underline the complexities arising from such policies. The societal fabric of South Africa acts as a bulwark against divisive politics regarding national identity, stemming from a history of inclusive governance and non-racialism championed by the ANC. While some may argue that dual citizenship dilutes loyalty to a nation, the government's stance against South Africans joining the Israel Defense Forces, motivated by international political considerations, demonstrates the tension that dual citizenship can engender. The recent uptick in xenophobic sentiments, illustrated by the ending of the Zimbabwean exemption permit and the backlash against foreign nationals implicated in food contamination incidents, underscores the contemporary relevance of the citizenship debate. However, the ongoing societal transformation, coupled with an official acknowledgement of digital nomad lifestyles, may herald a future where the nation-state's constraints on personal identity are significantly relaxed. This Constitutional Court case, set against a backdrop of a society both connected and divided by identity politics, may serve as a threshold to more adaptable interpretations of what it means to be South African in an increasingly interconnected world. Thank you for choosing Satori News.